Right.
Members of the jury, the plaintiff is here asking you and me to take a large sum of money from the defendants, or some of them, and hand it to him. The law doesn't do that lightly or inconsiderately. The law assumes that that which a man has is his. And if anyone comes along and demands the money of another, as in this case, the law doesn't give it to him just because he is asking for it. The burden of proof is upon the one asking the money of another. The law will not act without reasonable certainty, that is, legal proof. If there isn't legal proof, the law keeps its hands off and lets the litigants go and continue in the same condition in which their own action placed them, that is, the law cannot cure every ill. The plaintiff asks for $50,000 from all these defendants. He wants a verdict against all of them. He must prove that in order to entitle himself to this money, or any part of it, the accident happened through the sole negligence of the defendants, and without any negligence whatever upon his part contributing to the accident. Negligence is the failure to exercise the degree of care that a reasonably careful, prudent person would or ought to exercise under the circumstances, not the highest degree of care, but reasonable care. A failure to exercise such care is negligence, and the claim of the plaintiff is that they were negligent. He was injured through the negligence of these defendants. Now, you must find that the negligence before he is entitled to recover. It's rather a difficult case for you, but nevertheless it must be settled, and this is the time to settle it. The case has taken up your time and the time of the court, the time of the lawyers, the time of everybody concerned. Now, the first question will be, how, in all probability, under the testimony, we must not draw upon our imagination. We must confine ourselves to a consideration of the testimony that has been given us from this witness chair. How, in all probability, did the accident happen under the proof? Let's not resort to the imagination. That doesn't open or mean we may not use our reasoning powers, the reasoning faculties that the good Lord has supplied us with. That's what I want from you, the exercise of that good common sense that guides you in your everyday affairs. Don't think if you are in court you have to resort to new and untried processes of reasoning. Just use the reasoning exercised in your everyday affairs. What we are after here, gentlemen, is the truth, so nearly as we can get at it. Who was it said, find the truth and the truth will make you free? Where does the truth lie? You have heard the witnesses come here, one after the other, to tell what he knows about the accident, under oath, and other witnesses contradict him. What are you going to do about it? Well, there is something within us that guides us to the truth or helps us to the truth. Now, you have seen the testimony here from the witnesses. You know what the interest is in the case. The plaintiff is deeply interested. He is asking for $50,000 against all these defendants. Now, we know what human nature is, and the law recognizes the failings of human nature, and the law requires you to weigh every word that falls from the mouth of an interested witness to see whether or not his interest in the case may not have shaded his testimony. They may not be so honest that they will tell the truth no matter how deeply interested they are, but how plentiful these men are, I leave to your judgment and your own experience. Now, I don't suggest to you that you believe or disbelieve any witness, the plaintiff or anyone else who has taken this chair. It is for you to place what value you want upon the testimony of every witness. And I have no right to influence your minds or to make any suggestion to you as to whom you should believe or whom you should not. The burden is upon the plaintiff. We must not guess. The plaintiff is obligated under the law, before he becomes entitled to the money of the defendants, to prove his case with reasonable certainty, with reasonable probability. The law isn't as unreasonable as to require absolute certain proof, because if you will stop to think, there isn't anything that's certain in this world. So the law that itself is the essence of common sense requires nothing but that which is in accordance with common sense, and it requires not absolute but reasonable certainty. That's what is meant by the burden placed upon the plaintiff to prove his case by a fair preponderance of the credible testimony, so that the testimony on behalf of the plaintiff, when put in the scales as against the opposing testimony, fairly outweighs it in the balance. And not in the number of witnesses or mass of testimony, but in the quality of the testimony. if the case is so uncertain?
I think I got it.
201.